Welcome to another edition of Dad's Divorce Live. My name is Rick Ortiz. I'm the editor of Dad's Divorce, and today with us we have Dan Cuneo from the law firm Cordell Cordell PC, and Dan is going to answer some of your Ask a Lawyer questions. These are questions that are sent in by our visitors. When they go to the Dad's Divorce website, there's a tab over there that says Resources, and you can click on that and then click on Ask a Lawyer and submit questions, and we try to either answer them on Dad's Divorce Live, or we answer those on the body of the website itself. So you'll see your responses from the attorneys of Cordell Cordell. They'll either pop up on the website or in the Dad's Divorce Live show. So we're going to jump right in and talk to Dan a little bit about some advice that he may have for our visitors. The first question: I married my wife 3 years ago, and she brought her 9-year-old daughter into the relationship. I love the little girl, and I see her as my daughter. My wife shares 50-50 custody with her ex-husband. His work schedule has him getting her up at 5 in the morning and dropping her off in the a.m. And he's not putting her to bed until 11 or 12 at night. Her grades are slipping, and the teacher is sending letters home. We know that he's not doing any homework with her or helping her develop socially. Me and my wife and the teacher have tried to talk to him, and he just gets angry and he doesn't listen. We want any child support. We don't want any child support or anything of that nature. We just want a more stable environment for our daughter. And he's asking, is there anything that we can do to change the custody arrangement without putting her father in a bad place, and just doing what's right for the daughter?
Well, you first got to look at it in what is in the best interest of the child. And if this were to be in the state of Missouri, what the court's going to look at before you can file a modification, they're going to look at what has been the substantial continuing change since the date of the last order. So I don't know if there's been a modification prior, or if it was just a dissolution of the decree, and then that's what they've been following since then. So we're going to go under that scenario that there hasn't been any modification, that they've had this decree, there's been no modification filed or ordered by the court since then, and they've been following the parenting plan, which is a 50-50 arrangement. So with that framework in mind, we're going to want to look at what is in the best interest of the child. And in this case, getting up at 5 a.m. is not in the best interest of the child. Going to bed at 11 o'clock at night is definitely not in the best interest of the child. There's been several studies that show that children need a certain amount of sleep in order to continue their growth and development and to do well in school. And so what this particular person is going to want to do is, since they've tried talking to dad and dad is just being unresponsive and uncooperative, then the first step they're going to do is gather all the evidence that they have. And the evidence would be contacts that they have with their teachers, any notes that they have from the teachers, correspondence, emails, or text messages that this person has sent to dad regarding what's going on with this child and the grades are slipping, and then fourth, want to keep dad's responses. Then you want to go in and draft what's called a motion to modify. And what you're going to allege are the substantial continuing change is the fact that since dad, or during dad's custody time, he's getting the child up too early. He's not helping out with the homework. The grades are slipping. There's been responses from the teachers saying that they've got some concerns. And so what the court's going to look at, as I mentioned earlier, is the best interest of the child. And the best interest of the child, at least in this particular case, is that there needs to be some stability and there needs to be advancement towards their education to help them out, to help facilitate them to continue to excel in their studies. And in the current situation, unfortunately, that's not happening. Mm-hmm. So from my understanding of the questions, I don't want to really penalize that or take away his custody. Mm-hmm. So what they can maybe do is do a consent modification where maybe during the school year the child stays with mom, and then dad can have evening visitation or extended evening visitation, or maybe instead of doing a 50-50 arrangement, they can cut back during the week and maybe make up for it on extended weekends, holidays, or summers. Now, I don't know exactly how they're doing the 50-50. Is it if they're alternating weeks or if they're splitting days? Because you can cut back on the times that the child is spending the night with dad during the school year, which probably would be best in this case if this particular person doesn't want to really penalize dad or take away his custody time. But if not, then I mean, you have your motion on file, and then you're going to have to proceed forward with that. And then the people that you want to bring in to testify are the school teachers, any counselors, and I don't know, was there an age mention of the child?
It said that the daughter was 9 years old.
9 years old. And so, I mean, you may want to get a guardian ad litem involved. And what a guardian ad litem is, it's another attorney who is to represent the best interest of the child or the children. So in this case, there would be a lawyer, and he or she would represent the best interest of this 9-year-old. And then this particular person would talk to the school teachers, the counselors, the principal, take a look at the academic records, talk to mom, talk to dad, or whoever, you know, other witnesses that you think would be beneficial to the case that you would want this particular guardian ad litem to talk to. And then he or she will make a recommendation to the court based upon their investigation, and then submit that to the judge. And the judge can either adopt it in its entirety, take part of it, or come up with his or her own parenting plan. But it seems to me that there needs to be something done, because it seems as if we're going down a downhill spiral in the grades here. And unfortunately, it's because, you know, I'm not sure what dad's situation is. And that's something that probably needs to be looked into, as well as why is dad getting this child up at 5 a.m.? Why is the child going to bed at 11 o'clock at night? So there's certain issues that haven't really been brought up, and it's probably because the person sensing the question doesn't really know the answers to it. So once we find out really what is going on dad's side, then I think we'd be in a better position to try to resolve the case or move forward. And that can be done through the discovery process as well. Once you're on file, then you can go ahead and send interrogatories, which are questions that you can draft and tailor to the particular case, wanting to know, why is dad getting up real early, taking the child to bed real late? What involvement does he have with the homework? Does he even know that there's homework? Does he have involvement with the teachers? If so, what have those involvements been? Because those are things that the court's going to take into consideration.
Sure. Right, so you've got to do what's right for the kid.
Exactly.
And you have to, whether that means trying to adjust a work schedule or adjust the custody schedule, you have to be sure that kid can grow. The second question, and these questions this week all have to do with children and divorce. The second question is, my ex-wife is getting divorced for the second time and was married for less than a year. The writer is concerned about the emotional effects that this is going to have on his children in the future if she continues this pattern. She also has a history of not being able to keep a job, and there are questions about her mental stability. I'm wondering, says the writer, if these arguments will hold up in court if I choose to push for primary custody. If not, he'd like to know how to go about ordering a psychological evaluation for her, and if ordering an evaluation would help.
Well, that question is kind of compounded and compact with a lot of different components attached to it. I guess really generally answering the question, those arguments on its face, I would tend to say no in the state of Missouri. However, what you're going to want to do is file the motion to modify, which we talked about previously to the writer that submitted in the question regarding the child being up early and being up late. And then once you have that motion to modify and file, then you can conduct discovery, because you're going to really find out what's going on. Because my understanding of the question is they're trying to prove there's some type of instability with mom. And that could be one of the factors that the court takes into consideration, because you want to be able to provide a stable environment for the children. And if that environment is not being provided by the primary custodial parent, then you could potentially come in and modify it. The fact that mom is getting married and remarried and married and remarried on its face is not going to be enough. The court's not going to penalize someone because of failed marriages. With that being said, you want to really look into why the marriage is not working out. Is it because she's marrying somebody who's been convicted of felonies or a crime that it would be, harmful to children? Or is there abuse going on? I mean, what's going on that's not making these relationships work? And depending upon that, is the child witnessing certain acts that the child should not be witnessing? And so, again, you're most likely want to get a guardian ad litem involved, especially if you're trying to change the custody. Most judges will automatically appoint a guardian ad litem. Or if there's going to be a custody dispute, then the judges automatically will appoint a guardian ad litem, especially if you allege neglect or abuse. And in this case, it sounds as though there could be some potential neglect going on. So you're going to want to get that guardian ad litem involved, which, again, is another attorney licensed to practice in that particular state here in Missouri. And he or she will talk. Is there an age limit or an age for these children?
it doesn't mention an age in this.
Well, in most situations, the guardian will still meet with the children, you know, dependent upon their age, and then meet with the parents and doctors and other teachers that may be involved.